Hi guys, it's Kathy. I hope you're doing well. Sorry about that, guys. Sorry. Okay, I did get a little bit of court cases since we were last here a couple hours ago. Here we go.
Find that case file. All right, Ms. Linville, did you have any questions about the rights that the court went over earlier?
No, sir.
In your case, you're on probation for a Class 5 felony.
Yes.
Class 5 felony carries with it a possible sentence to the Department of Corrections of between 1 to 3 years. With exceptional circumstances, that could be reduced to as little as 6 months, increased to as many as 6 years. There'd be 2 years of mandatory parole and a possible fine of between $1,000 and $100,000. You have the right to be represented by an attorney in your case. You've been represented by Ms. Bacon. Do you have any, are you satisfied with your attorney services?
Yes, I am.
Do you need any further time to talk with your attorney about your case?
No, sir.
In this case, I have an agreement noted that states you intend to admit to violating condition number 7. Condition number 7 states you will submit to drug and alcohol testing as directed by probation. It's alleged you missed random drug tests on April 23rd and April 9th of 2026. There's an agreement for a 90 days in jail with 90 days credit for time served. Is that the agreement?
Yes, Judge.
And close the case, basically unsuccessful probation?
Yes.
Ms. Linville, did you have any questions about your rights?
No, sir.
Understanding your rights in this case, do you wish to admit or deny the allegation you violated condition number 7, failing submitting to drug and alcohol testing as directed by probation? Do you wish to admit or deny that you violated that condition?
I admit.
Are you under the influence of any alcohol or drugs that would influence your ability to understand today's proceedings?
No, sir.
You suffer from any mental condition or disability that affects your ability to understand these proceedings?
No, sir.
Court finds the defendant has knowingly and voluntarily and intelligently waived her rights in this case. Plea is entered into knowingly and voluntarily without any undue influence or coercion. She understands the possible penalties and the consequences of the plea. Court will accept the admission at this point in time. Are we going to immediate sentencing?
Yes, Judge.
Yes, right. I guess my first question is, we have a Class 5 felony with basically no success on probation. It's already been extended once. Why are we terminating?
A fair question. Court's indulgence, I'm sorry, this computer's freezing up.
I can't do that.
Ms. Bear?
She did excellent on probation in the beginning. She went to IRT, she did a year at sober house, she was working full-time at Arby's. And then she got back into meth and just everything fell down from there. We couldn't get her back on track.
So I guess I'm not getting involved with whatever we're doing here. I'm just looking at it going, why is ComClone not an option?
Well, she's also on a deferred, so she would be deferred and having a conviction in the record now.
True, but a conviction with 90 days jail and closed and done on a felony.
Right. Well, I think to answer the court's question, Ms. Bear and Mr. Karshner and myself had discussions via email, and Ms. Bear obviously worked with Ms. Linville on these cases the closest. And the best outcome for Ms. Linville is to close this out with the cut of her time served, taking into consideration what Ms. Bear made a record to, which was that at one point in time, there was belief that this case would close out successfully. We're just not there right now.
Get him, Judge. Monica, 11-month streak. Being subscribed on Prime. Thank you so much. I really appreciate it. Thank you.
Mr. Karchner?
So, Your Honor, at the time this case came in, Miss Linville was on a pretty clear downward trajectory. She had the vehicular looting in this case. At that time, we noted that she had 6 failures to appear pending when she was arrested in these cases alone. The offer, and from what I had been told, everything that had been happening to Miss Linville was related to substance abuse. Probation was an effort to try to curtail some of that. That, of course, didn't work. We're now in a position a year later where there was some success, and I frankly wasn't sure how much the court would credit that success in light of any request we might make. I deferred to probation in this one based on their feelings about whether there was sufficient consequence or not. I was on the fence with this. With that in mind, that's the people's record in terms of how we ended up here.
When reading the complaint, and I don't fault the parties for looking at things saying she did really well at first, what kind of credit do we want to give her for that? This reads like someone who has given up and has completely fallen off recently. And then when I read a statement that the defendant requests to go to jail rather than to continue probation. Well, this is a felony case. And 90 days jail, which is barely what she has. I mean, I have 79 days plus 16. So, barely have 90 days for a class 5 felony. And I went back and looked at the warrantless. This was not a not serious offense. I mean, just going 90 miles an hour through 4-way stop signs all over town, while being chased by cops with outstanding warrants. I think community corrections is a better option than giving up on her and closing the case out. So are the people ready to proceed to a hearing? Because I'm not going to accept this.
Yes, Your Honor.
Judge, I would ask to withdraw the plea and allow me to convene with Ms. Linville about our options going forward and a potential opportunity to rediscuss negotiations with Ms. Baer and Mr. Karstner, Judge.
That's fine. I'll give you that opportunity. I want to make it very clear. I feel like this is just giving up on somebody that who's really given up on herself. And I know how much time has been put into this case. It's an older case, but I'd like to see something aside. Plus, it is a felony case, not a run-of-the-mill, not a misdemeanor, not something less serious. So I'll give you that opportunity. We'll come back in 2 weeks. June 4th at 1:30 for revocation. All right, is this Mr. Willard?
Yes.
Thank you. We'll call 26 CR 5008, People versus Christopher Willard. Mr. Willard appears in custody from the Morgan County Jail. He is represented by Ms. Bacon, who is present here in court today, the people by Ms. Wired. We are set for revocation proceedings, but however, the court has, in response to a sealed motion, ordered a determination with regards to competency. Ms. Bacon, do you wish the court to advise your client with regards to his rights on a competency evaluation process?
Yes, Judge.
Locate that. All right, Mr. Willard, there's been a motion filed in your case, and the court has granted that motion to determine whether or not you are competent to proceed in this matter. Competency is a process to determine whether or not you have the present ability to assist with your defense. You have the right not to say anything to the psychiatrist during the competency examination. Statements to the examiner can be used against you at the guilt phase of trial or at rebuttal or as rebuttal or impeachment evidence. And this is a probation revocation, so it can be used during those periods of time during that particular type of a hearing. You have the right to confer with counsel before submitting to the competency exam. The court will appoint an attorney for you at state expense if you are unable to retain counsel prior to the competency evaluation. You are in custody. You do qualify for the public defender. I do understand there might be something going with that. I will watch for any appropriate motions with regards to that. If you do not cooperate with the competency evaluator and other personnel providing these services, and the lack of cooperation is not the result of a developmental disability or mental disability, the fact of your non-cooperation with the competency evaluator and other personnel providing ancillary services may be admissible in the competency or restoration hearing to rebut any evidence introduced by you with respect to your competency. When a decision is made as to your competency, if you wish to contest that decision, you have the right to request a competency hearing. At the hearing, you and the prosecuting attorney have the right to be present in person, to examine any reports of the evaluation or any other matter to be considered by the court as bearing upon the determination of your competency, to introduce evidence, summon witnesses, cross-examine opposing witnesses or witnesses called by the court, and to make opening and closing statements and argument. The court may examine or cross-examine any witness called by you or the prosecuting attorney at a competency hearing and may summon and examine witnesses on its own motion. If you are found to be competent to proceed, then the case will proceed as scheduled for probation revocation after such determination, and a final determination is made by the court. If you are found not competent to proceed, the court may order you into restoration services, and you would be ordered to cooperate with those restoration services. Do you have any questions about the competency process at this stage?
No.
Okay, and we do have a specialized competency court with a different judge, and that's where you are going to be, your case is going to be transferred at this point in time. So that is a much more specialized that has different resources available and is able to handle competency questions more efficiently than
Did you see that, Michael? What does that mean?
this courtroom can. So that's what's going to happen in your case at this point in time. Do you have any general questions for me at this time?
Yeah, I want to know like how I can be released on a PR bond.
Yeah, Judge, we also want to address bond today.
I understand. Let me get to bond here in a moment, but any questions about the competency process?
Not at this time.
Okay, if you have any at some point when you have your attorney talk to your attorney, and you can also, you may be given some opportunity in the competency court itself as well.
It's absolutely horrible.
Okay, well, anyway, let's talk about bond at this point in time. Currently, bond in this case is $700 cash or surety. Ms. Bacon.
Thank you, Judge. I am requesting that Mr. Willard's bond be converted to a personal recognizance bond. I think that based off of this case, we're here for a probation revocation. However, given the timing, Mr. Willard will be supervised on probation out of custody. And Mr. Willard's source of income is Social Security. So without access to that, he is unable to support himself or post bond. For those reasons, Judge, I am asking to convert the bond in this matter from $700 to a personal recognizance bond.
From the people?
Hold on, people. I have a burning question. Bobby, when you say got a lot of friends down there. Are you telling Bren that you have a lot of friends down there? Are you saying that Bren has a lot of friends down there? Or are you asking Bren if he has a lot of friends down there? And if it's you that got a lot of friends down there, do they say bye? I don't know.
I get that he just got a PR bond, but here's the problem. Mr. Willer just pled guilty, whatever, last week. And then 2 days later was arrested. So I'm not certain how compliant he really is on probation. In other words, I understand Ms. Bacon's argument is that he's going to be supervised, but is he? Because I don't see that he's even availed himself of that yet. I suppose the court can err on the side of believing that he will, but I'm not confident in that. Again, he was just granted a $1,900 or $1,500 PR bond on the 19th. That was Judge Leash who granted that. And this is $700 cash only, I believe.
I think it's cash or surety now.
Cash or surety, okay. I mean, the court could convert this to a $100 cash only. But if the court's going to grant a PR, then I think it has to match the PR that was granted in the misdemeanor case, as this is a felony matter. Oh, and I've been told by his would-be probation officer that he refused to sign the conditions of probation.
Yeah, at this point in time, reading the allegations that he admitted to in this case, I mean, this involves throwing a cinder block through the window of the sheriff's department in the middle of the night. The fact that he picked up a new case within 4 days of being placed on probation and he refused to sign the probation terms and conditions doesn't give the court any confidence that he'd be successful being supervised. At this point in time, I'm denying the motion to reduce bond. We'll set the matter into competency court on June 9th at 10 a.m. Anything further today on this case, Ms. Bacon,
No, thank you, Judge.
Ms. Wyatt?
No, thanks.
All right, we'll see everybody June 9th, 10 a.m., competency court.
Okay, this next one, the voice does funny things to my belly. Wait till you hear this voice, guys. It's coming. They can't take a joke at all. Not at all. Come on. Yeah, me too, buddy. Wow. I just forwarded it 25 minutes. We were just about to watch 25 minutes of people yawning. Come on, Judge.
Good morning, Your Honor. Chase Allsett for the people.
And Olivia Moran on behalf of Mr. Quintana Hinos, who appears via Webett's in custody.
All right, and thank you, and good morning to all of you. We're set for appearance on arrest warrant based on the complaint for revocation of probation. Ms. Moran, do you waive any further reading and advisement?
I do, Your Honor.
Estamos llamando el caso 10R320 del Estado contra Quintana Hinojos y pueden ser comparecencia empezando por la Fiscalía. Gracias, buenos días, señoría Chase Allsett, de parte de la Fiscalía de Olivia Moran, de parte de la Defensoría Pública. And for the record, this is Luis Alvarez, CCICO 22005. Muy bien, estamos por orden de arresto y están pidiendo revocación de la libertad condicional. Señorita Olivia Moran hace renuncia, email, lectura y notificación. Así es, su señoría.
Listen to that voice. He has a great voice, man. Telemundo.
All right, thank you, Mr. Alvarez.
Of course.
All right, we are set today, as I stated, for appearance on the arrest warrant. Ms. Moran, how did you want to proceed?
Your Honor,
Bien.
we're asking, sorry.
Como dije, estamos por comparecencia por orden de arresto. Señorita Moran, ¿cómo quiere proceder?
Your Honor, we're asking to address bond.
Su señoría, estamos pidiendo lidiar con la fianza.
Are the people prepared to address bond today?
¿La fiscalía está lista para tocar ese tema el día de hoy?
That's fine, Your Honor.
Está bien, su señoría.
All right, Ms. Moran.
Bien, señorita Morán.
Yes, Your Honor. Mr. Quintana Munoz is currently on a no bond hold. We'd be asking the court to impose a low cash surety amount. Mr. Quintana Munoz is indigent, and even a relatively lower cash surety bond would amount to a no bond hold. Additionally, Your Honor, Mr. Quintana Munoz is on Medicaid, which highlights his indigency status and inability to afford a high amount of bond. He does reside in Colorado Springs and has a stable address. He does have a car to get to and from court. He has a sister and some cousins who are in the area, highlighting his lack of flight risk. He does want to address this case. Mr. Quintana Munoz additionally, unfortunately, suffered from a brain hemorrhage about 7 years ago, and is still actively receiving follow-up treatment for that through Medicaid. For all those reasons, Your Honor, we are asking the court to impose a lower cash surety bond. Mr. Quintana Munoz does want to address this case from out of custody and does want to address the allegations made by probation. So we would be asking for a low cash surety bond. Thank you.
Sí, su señoría. El señor Quintana Hinojos está en una retención sin fianza. Actualmente está viviendo en Colorado Springs. El señor Quintana Hinojos es indigente. Incluso una cantidad baja en efectivo sería equivalente a retención sin fianza. Está bajo Medicare y eso establece también su nivel de indigencia. Tiene ahí su domicilio en Colorado Springs, tiene carro para llegar y volver de sus futuras audiencias ante el tribunal. Tiene allá una hermana y unos primos, lo cual establece que no es riesgo de fuga. Además, tuvo un derrame cerebral hace 7 años y está recibiendo citas de seguimiento por medio de...
Why did the judge let him talk so long when there's an interpreter right there? Trust me, I don't mind. I'm just enjoying listening to this interpreter's voice is amazing. But that was rude.
Medicaid, entonces pediríamos que por esos motivos le otorgue una cantidad en efectivo por medio de fiancista que esté bajo, y el señor Quintana Hinojos quiere lidiar con estas acusaciones.
He absolutely should be in radio and not a translator. Maybe he is. Maybe this is his second gig.
De incumplimiento de libertad condicional fuera de custodia.
Thank you. In the people's position?
Gracias. ¿Qué opina la fiscalía?
Thank you, Your Honor. Your Honor, the people are asking that the no bond hold remain. I'll note a couple of things for the court.
Gracias, señoría. Estamos pidiendo que permanezca la retención sin fianza y le hago constar un par de cosas.
The defendant is on SOISP probation, which, as the court knows, is the most demanding and strict probation that someone can be on in the community.
Como el acusado está en libertad condicional SOISP, que como sabe su señoría es el más exigente y estricto para estar libre en la comunidad.
And the information in probation's complaint is incredibly concerning.
La información contenida en la queja de libertad condicional es increíblemente preocupante.
The defendant is threatened and brandished a weapon at probation officers at a home visit.
El acusado sacó...
Yep, probation officer came to his home, so he pulled out a knife. Why? Remember that guy did that at the CPS worker who was coming to... He lost custody of his children, him and Honey. Honey was his girlfriend. And the CPS worker came over and he was brandishing a knife to show them that he knew how to brandish a knife safely. Sherry, thank you so much for the sunshine. Thank you.
Y amenazó a los agentes de libertad condicional con un arma en una visita al hogar.
He had an unauthorized phone.
Tenía teléfono no autorizado.
Had unauthorized photographs on there. Had visited pornographic websites with that phone.
tenía fotos no autorizadas en ellos y visitó sitios pornográficos con ese teléfono.
He had unauthorized interactions with minors, which was not approved by his probation officer.
Tenía interacción no autorizada con menores de edad, lo cual no estaba autorizado por su agente de libertad condicional.
Had also multiple times when he was in the community that was not often with an authorized safety plan, including a visit to a bar.
Tuvo varias interacciones con la comunidad no autorizadas, incluyendo una visita a un bar.
Your Honor, I think given that this is post-conviction and the defendant is not entitled to a bond, there are tremendous community safety risks here, not only to the victim, but also the community at large.
Dado que estos post con
CJ's baiting me. I didn't say it. Kelly, don't you say it either. You just let CJ's comment go by without saying it.
condena no tiene derecho a una fianza y creo que hay peligro tremendo de seguridad, no solamente para la víctima, sino para la comunidad en general.
The people do not believe there's any amount of bond at this point that would keep the community safe.
La fiscalía opina que no hay cantidad de fianza que podría mantener segura la comunidad.
I'll also tell the court that people have reached out to the victim. She is incredibly concerned about these allegations, and she wanted to let the court know that her request is for a no bond hold as well.
También hemos contactado nosotros a la víctima y ella está muy preocupada con estas acusaciones y lo que ella pide también es que se le retenga sin fianza.
And so for all of those reasons, people believe a no bond hold is appropriate. I think if the court is inclined to move from the no bond hold, probation was asking for a $200,000 cash or surety bond. That would be the people's request, but I think a no bond is most appropriate. But if the court is inclined to set a bond, I think it should be very high in that amount.
Entonces, por todos esos motivos, estaría la fiscalía pidiendo que se le retenga sin fianza. En la alternativa, si su señoría considera una cantidad, libertad condicional está pidiendo cantidad de $200,000, que es lo que pediría la fiscalía si es que está considerando otorgarle una fianza que se mantenga en una cantidad muy elevada.
All right, thank you. I did review the complaint for revocation of probation.
Muy bien, gracias. Sí repasé la revocación para queja de revocar su libertad condicional.
I was very concerned by the allegations alleged in the complaint.
Está muy preocupada por las acusaciones que se alega que en la querella.
In particular, the allegation that Mr. Quintano had a knife.
En particular que el señor Quintana Hinojos tenía un cuchillo.
Allegedly brandished a knife at the probation officers.
En teoría amenazó con el cuchillo a los agentes de libertad condicional.
Contact with minors.
Contacto con menores de edad.
And inappropriate use of his cell phone.
E uso inapropiado de su celular.
This time the court is not going to set a bond in Mr. Quintana Hinoe's matter.
En este momento no fijaré una fianza en el caso del señor Quintana Hinoa.
We are post-conviction and he is not compliant with the conditions of his probation.
Estamos post-condena y no está cumpliendo con las condiciones de libertad condicional.
And the court does have community safety concerns.
Y sí tengo preocupación de seguridad comunitaria.
All right. Ms. Moran, do you want to set this for a hearing within 14 days? Is your client waiving the 14 days?
Señorita Morán quiere fijar esto para una audiencia en 14 días. Su cliente va a renunciar al plazo de 14 días.
He is waiving, Your Honor. I'd ask if we can get this set for status in a few weeks.
Está renunciando, su señoría. Pido que si lo podemos fijar para estatus en unas semanas.
All right. Any objection from the people?
¿Se opone la fiscalía?
No, Your Honor.
No, su señoría.
I can offer June 18th at 8:30.
Puedo ofrecer 18 de junio 8:30.
That works.
That works, people.
Funciona.
All right. We'll see everyone back then for a status on June 18th at 8:30.
Bien, nos vemos todos para estatus el 18 de junio 8:30.
All right. Anything else we can address today?
Bien, ¿algo más que tocar el día de hoy?
No, Your Honor. Thank you.
No, su señoría, gracias.
No, Your Honor. Thanks.
No, su señoría, gracias.
See everyone June 18th at 8:30.
Para todos, 18 de junio 8:30.
I'm gonna be pretend speaking Spanish all day today. Okay. This guy, I do feel bad for him. That's true. How is New Zealand today, JK? Thank you so much.
You roll the window
down?
Hey, roll the window down.
Partner, are you having a medical emergency? The party is conscious and breathing, but he's not responsible. Fuck you. Fuck you. What's going on, man? Fuck off. What do you mean? Hey, we're just checking on you, man. You're checking on me? Yeah. Hey. Hey, relax. What the fuck? Oh. What is that?
Give me this arm. Give me this arm.
Yeah.
Give me this arm.
Fuck you. Oh my God. Fuck you. Stop fighting. What is your problem, kid?
He's bleeding.
Get off me! Get off me! Fuck you. Get off me. Just relax, man. Fuck you. Came here to check on me. Really? Yeah.
Yeah, that's all we were here to do, man.
Two.
Yeah.
Get off me.
Should be noted that he does continue to talk aggressively to officers, threatening them as well as saying, "fuck you." This is particularly concerning, given that in the passenger side of the car, there was a gun. And so the reason why we were asking for this punitive sanction and understanding the safety, the risks to the community that was present here, as well as to the officers, we do think that a punitive sanction is appropriate in addition to the probation that we are asking for Mr. Butt to serve. Thank you.
Okay, thank you. And Mr. Lilly, any statement of mitigation?
Absolutely, Your Honor. You know, I look at that video and I'm struck, first of all, by the fact that that's where I live. 65, I live off of 65. That hill in the background behind the elk fence is where I live. I would tell you, Your Honor, I probably know those officers. I don't recognize them, but I probably do know them. My client stands before you, frankly, shaking right now. He is utterly ashamed, humiliated, humbled. I think there are probably more words that I could come up with there as to his behavior on that night. I appreciate the prosecutor saying that one of the parts of sentencing is to promote acceptance of responsibility because he's here to take.
He's sorry. He's a changed man. He's starting a new job. He has to take care of his sick mom. Come on, lawyer, you could have done better than that.
Responsibility. He, in fact, pled guilty to both the DUI and the resisting arrest. Frankly, a deal that under most circumstances I would not advise a client to agree to. But in this circumstances, he is one of very few clients who came into my office and told me he did it and wants to plead. Most clients, when they come into my office, have a reason, an excuse, or a but you don't know the rest of the story. And having done this a long time, I'm aware that there is always more of the story. Unfortunately, the rest of the story doesn't always make things better. That was not Adam Butt when he came into my office. When he came into my office, he said, "I can't believe what I did." He actually didn't have the greatest memory of it. He was absolutely 100% drunk that night. He was absolutely 100% driving. And he wanted to plead right away. And we pled him to essentially the top charge and the next most serious charge on this because that's what he wanted. He wanted to take responsibility. He is in his 50s, Your Honor. He's never committed a crime in his entire life. One of the things read out by the prosecutors to prevent this from happening again, I think when you hear from Mr. Butt, and I think when you see it physically before you, and you combine that with 50 years, over 50 years of never doing anything criminally wrong before, you'll come away convinced he's never going to do anything again that is anywhere near remotely like this. There was a gun in the car. Actually, there's more. All that's in the police report is accurate in terms of what was in the car. He did not brandish it. He didn't threaten it. He didn't say anything he didn't do anything like that. It was there. He was totally out of it. He was going through a divorce, and that is, of course, never an excuse because, well, 50% of Americans go through a divorce. But
Yo, if you go through a divorce, you're allowed to get drunk because it's an amazing, it's a celebration.
he was going through a divorce. He was drinking heavily. He has a son that means the absolute world to him, a son that needs him around, a son that he is learning to parent in a different way, I think, when you go through a divorce than when you're there with two co-parents each day. I'm not passing any sort of judgment on that. I think a lot of people have to go through that, and that is a hard prospect for him and a prospect he has struggled with. He has done well on pretrial. It looks to me like there was one positive for alcohol through dependency of this
Guys, we want the case dismissed against him. He has a great accent.
case based on the pretrial report that I see, but he acknowledges and knows that what he did, the way he cursed at the officers, the way he was angry at the officers, the way he was non-compliant and had to be taken down quite hard into the gravel and what appears to be snow there. He admits that he frankly deserved to be taken down like he was, that he was not cooperating and that he went beyond not cooperating, that he was downright rude, mean, and vulgar to them. And he's going to tell you how very sorry he is for that, Your Honor. I don't, there's a saying I use in felony a lot that I almost never say in misdemeanor, but I think it applies in this case given what's being asked for. We reserve prison for those who we are afraid of, not those who we are merely angry at. I didn't make that up, but I think it is a brilliant.
Is that what the judge just said yesterday in our Georgia case? Because that would be crazy. It is in another case. Either it was in Georgia last night or it's in one coming up today. Two different people said that phrase yesterday in court cases.
Thing to say. I think police have a right to be angry at him. The court has a right to be angry at him. He should be angry at himself. I believe he is very angry at himself. But at the end of the day, he is not a threat to society. He is not someone that needs to get locked away. Probation is appropriate on the DUI. Probation is appropriate on a first-time resisting. And frankly, if the court feels like he needs more to learn this lesson, I think the usual application would be extra community service. Make him give back to the community that he took from in the sense that he committed a crime, that the community safety, that the officers didn't just have a routine traffic stop. They're actually telling the truth on that video, that they were there for what was a call for help. It was not necessarily a call for a drunk driver. Now, I think they probably had their suspicions walking up to where he was parked, and nobody would park there in their right mind. But the reality of it is they were there because somebody was concerned about him. A concerned citizen called and was concerned about him. And obviously, in his incredibly altered state, he did not know it. Because of his refusal, we don't know what his alcohol was that night, but he would tell you he was quite drunk enough to the point where he doesn't remember much of it, drunk enough that when we tell him about him and show him this too, I mean, you can see the expression on his face, Your Honor. Shame is probably the best word that I can come up with. But all of the other parts of the sentencing statute make sense here. He's taken responsibility. He is willing to do whatever it takes to repair the harm to the community. He really wants me to emphasize, and it makes sense to me, that his son is his entire world, and it is his goal and desire to be there for him in every way he can, and to take care of him in every way he can, and that he's just ashamed. I mean, he took care of his elderly grandmother, as part of his life. And he taught firearm safety. So he knows that gun sitting on the seat is absolutely inappropriate, that is not proper firearm safety in any sense of the matter. And he knows that. And frankly, had he been in his right mind, he would have known that at the time, and he was not. So I don't think there's anything more for me to say other than, Your Honor, I believe that he is genuinely remorseful, and he's going to tell you that himself.
And did he got arrested that night? Did he serve a day or two in custody?
He served, I think it counts as one day that he was in custody, but he also has started the level 2 education, Your Honor, and has been going through that as well.
Okay, thank you. Mr. Butt, is there anything you'd like me to know before I impose my sentence?
I'm so sorry. This will never happen again. I'm scared and I never, with all due respect, ever want to see this courtroom again. I'm very sorry. It was not me that night. Sorry.
I appreciated the mitigation that was filed on your behalf, because I think it gave me a better idea of the person that you are outside of this night. And I think that it sounds like you were going through some personal stuff with your divorce, and then that kind of spiraled into the alcohol that night. You have come in and taken responsibility, and you've, for the most part, been fully compliant with pretrial supervision. I believe that positive test is probably you coming to the realization about kind of the role of alcohol in your life. And sometimes we see that when someone is that intoxicated, and then it takes them a minute to realize, like, you can't be drinking. I think that this next year will know that you've understood this. This is the type of case that typically when someone has a firearm and they are in front of me, that I do consider jail, because I think if you're an owner of a gun, you need to be very responsible with it. And we have laws, and if you're not following the laws, then it leads to other devastating consequences for other people. One of which is being that drunk and then having that easy access to a firearm. However, you have done a lot of work, and so I am not going to impose any additional jail than the day that you've served. I will hope that you realize, though, that, all the things that you are thinking in your mind as you stand before me of, like, think of my son, think of my job, think of all these people that I take care of. Ultimately, I can't give more consideration to those people than you. And so going forward on this probation, you have to be successful, not just for those people, but for yourself. Because ultimately, on a case where the prosecution asks for 60 days jail or upfront jail sentence, and then you come back on a revocation, I guarantee you're getting jail, because that will signal for me that I was way too easy on you. And everyone is on their best behavior at sentencing. It's what you do after today. But what I'm looking at is the bigger picture of you, is that you were at a really low point in your life, and you've started to put in tools to make sure that you don't do this again. But that means then in the next year, you have to be fully compliant with the monitored sobriety. You have to do everything. And in the back of your mind, I think you should just remember that you are have the 180 days jail, 120 days jail in the other charge that is just going to be hanging over your head. So understand that we're both on the same page. If you come back on a revocation, you're going to get jail, because I'm going to give myself a lot of notes about it, about what the prosecution asks. So procedurally, I'm going to impose 12 months supervised probation. I think by 12 months, we'll know if you're successful. And that will be on count 1 and count, I believe that's count 3. And so those will run concurrent or together with each other. You'll have to complete you'll have to complete the treatment that's recommended in your substance abuse evaluation in order to have no alcohol and no drugs. At this point, I am making a finding that the use of marijuana is contraindicative of the goals of sentencing. I think you need to be sober for this next year. So no use of marijuana as well. You'll be on monitored sobriety at probation's discretion. You have to complete a MAD victim impact panel, 48 hours of community service, and you cannot drive without a valid driver's license. I will suspend a $600 fine and 180 days in jail on the DUI and 120 days in jail on the resisting arrest. And that will be on condition that you fully comply with probation. Good luck. I think that you will be successful, and I hope that you are, and that you look at that as your low point, and then you just work your way out of it, and that you don't come back to court. You are welcome to come back and tell me about your year of sobriety, but I hope you don't come back on a revocation. So, all right. Good luck, sir. Thank you.
I don't know if he had an interlock. We don't normally see first offenders for DUI cases. They're just not really great clips. So I can't tell you if they normally put an interlock on a first offender, but I don't think so. First offenders are usually just a now, unless they did something really bad. Here we go.
Boom.
Thank you for being here today.
This is also his and my dog.
It's my best friend.
Thank you. Ms. Vizino, I would like to hear the people's person as well, the people's position, as well as your record regarding VRA, and if there are any victims present who wish to be heard, I'll be happy to hear from them.
Yes, Judge. And so we are in VRA compliance. One of the victims, so I'll give the two VRA victims in this case. So from Mr. Cruz, he is not objecting to a PR bond or modifying bond. His main goal is to keep the defendant away from him and his residence. I've also given Mr. Henderson a heads up, but we are asking the court, I have a proposed protection order. We just need to fix the address. So I'm just asking the court to do this new protection order with the exact same mirror what was done originally ordered, but it just has a corrected address for box 9. And then the other VRA victim, Ms. Barr, is here and would like to address the court, so I'll have her go first.
Ms. Barr, please come on up. Welcome. Thank you.
Thank you. I would like to start off by saying, yes, it was an altercation that shouldn't have gone that far.
I think they're neighbors, not boyfriend and girlfriend.
The bond to stay the same. I don't sleep at night. And one of the things he did say to me was that he would put me in the ground with his mother. And that was before the strangulation. I did not use a taser until he was throwing my ex-husband, because we are not in a relationship, around the kitchen like a rag doll. My ex-husband has scoliosis in his back and has had multiple open heart surgeries. And one of the things he threw my ex-husband on was a bar stool. And that was on his back. I don't think anybody in the community is safe. I would also like to ask for him to go to jail, because this is a matter of his girlfriend will not stop texting my ex-husband, trying to get him to drop the protection order. That is not okay. She has sat there and harassed my ex-husband for as long as this case has been happening to drop the protection order. She does not care about our safety. He does not care about our safety. I had to go to Hilltop for a forensics exam. I just supervise visits with my kids at Hilltop. I can't look at Hilltop anymore and think of it as a happy place. It affected me a lot because I feel like I wasn't strong enough. That I wasn't strong enough to protect my family, which includes my ex-husband, because we do share children. I didn't think I was strong enough to protect myself, and it's been haunting me for a while, because I've been in multiple domestic violence relationships. And when I got out of them, my one thing was to make myself strong enough to where I wouldn't have to go back to that place.
Sir, the judge's eyebrows are going together and she's getting some facial expressions going on. Judges don't normally do that, so you might be in a bit of trouble here.
This put me at an impasse where I feel like I'm not worth anything. And I would just like to have my life back. I would like to stop waking up at night screaming, or wake up at night feeling like I'm being suffocated because I feel the hands around my throat. I had to see my children with bruises on my neck and bruises all over my arms. And that's the sight I don't want anybody else to see. I would also like for anger management classes, because I feel like not only will it help the community, but it will help him as well. And I would like to ask for a no contact order, between me and my family because his girlfriend doesn't know where my mother lives. And that's who has custody of my children right now. I'm working to get my children back. But I do fear for my children, especially since she won't stop harassing my ex-husband about the protection order. And that's all. Thank you.
Thank you very much. Ms. Fazzino.
Yes, Judge, we join Ms. Barr's
Yeah, but look at how nice the carpet is.
request for the bond to remain the same. I was just reviewing the videos of this incident. The Ring doorbell camera videos have been disclosed to Mr. Henderson and are on evidence.com. I'm not exactly sure when they were, but they have been. I was briefly reviewing those. I mean, it's very clear this is a brutal assault. I mean, he is going after Ms. Barr. He is aggressively punching Mr. Cruz. I will need to see if there's any volume on them. But this clearly, this got out of control, but this was the defendant getting this out of control. The verbal argument then to escalate into a strangulation, this serious, and then with that's just simply not an appropriate reaction to escalate something verbal, no matter what was said, into what is displayed on these videos.
I wish we would see her tasing him on a video.
Category 2 and does not have a ton of FTA history. But this is a situation where it's, despite that, and that he may not be a flight risk, I do think he is a significant community safety risk. This is just an extremely violent, alarming assault on people that he was living in close proximity to. And so even if certainly we would ask that he is not allowed to be anywhere near them. We would ask for the no contact order to remain in place with the corrected address. But regardless, I'm not sure that will.
JK, Andy's sorry, but the judge doesn't know all the facts. Right? The judge doesn't know the whole story. That's probably what he's going to say.
Will be enough. This is kind of inexplicable behavior that is displayed in this offense in these videos. He does have criminal history, whether it's older or not. Certainly if it's older, that is a thing for the court to consider, but that doesn't negate that it happened, and it doesn't negate that he does have some past history that is assaultive. And so certainly he's not headed in the right direction where he's picking up this serious assault case, having that history. So he does not appear has learned from that and has learned how to deal with whether it's anger, whether it's substance abuse, whatever is going on, he is not dealing with it in the correct way. So we would certainly ask for the court to keep the bond where it's set. We think that's appropriate given what happened in this case and the input from the victim. If the court is inclined to modify the bond to lower it to do anything else, we certainly would ask for all the prior conditions to carry over. And if the court is in any way inclined to lower the bond or do PR or let him out, we would certainly ask for that GPS monitor to be affixed upon release so that we can see where he is. I think that that might be the only thing that might give Ms. Barr a way to sleep at night, but certainly I think having him in custody for a while longer is certainly appropriate given what happened in this case. If the court does modify the bond, in addition to the GPS, we would also be asking for some sort of mental health evaluation to figure out what is going on here. Of course, I believe pretrial services have been ordered. Does not appear that drug testing or no drugs or alcohol was ordered. Oh, and I guess I will note, looks like I think GPS was ordered. So I think on the original bond, the $25,000 cash only bond that Judge Romset, there was already a GPS 1,000-yard restriction.
Dollar restriction.
Yeah. And so he did, to Mr. Alloway's credit in the pretrial services report, he did.
Fletcher, good job. JK, thank you so much. I appreciate it. You got P. Barnes. Thank you so much.
Say that he had a past problem with substance abuse. So if that in any way contributed to what happened here, we would ask the court to consider, he does have some criminal history that indicates that might be the case, that if the court is inclined to lower the bond, that we also have no drugs or alcohol in testing so that we can make sure that every effort is being put towards keeping the community and the victims as safe as possible if he's not in jail. And then I would ask to approach, I'm going to show Mr. Henderson with the proposed protection order.
So in setting this bond, I first want to speak out directly to Ms. Barr. Ms. Barr, this incident, unfortunate as it is and as traumatizing as it must have been for you, does not define your worth.
That's right, Judge. Good job. Good job, Judge.
Your worth comes from you. I want you to know that. I also want to encourage you to reach out and seek some resources and therapy to help you through this. No doubt very traumatizing for you. Mr. Alloway.
Yes, Your Honor.
The record before me reflects that you have lots of support in the community. Lots of family, lots of friends, lots of people who care about you.
Yes, Your Honor.
An incident such as this goes from verbal escalation to what is described and what the affidavit verifies that there is Ring video footage to confirm a violent assault on another is not a normal reaction to a disagreement. That is not how we expect people to behave towards one another in an ordered and civilized society. I don't know what was going on for you in that moment. I don't know what the catalyst was for you, but the record reflects that you were the catalyst that escalated this incident to a violent and brutal attack on two other human beings. The court would be remiss if I did not recognize the extraordinary risk to community safety that is presented in such a circumstance. I am going to add as a condition of your bond that as a condition of any release, you must obtain a mental health evaluation and comply with all recommendations for treatment. I hope you'll take that very seriously.
Yes, Your Honor.
I am going to keep the GPS requirement set at 1,000 yards. I am going to correct the address. I am going to prohibit you from being within 1,000 yards of wherever Ms. Barr is found, of wherever Mr. Cruz is found, and of their home. To the extent that Ms. Barr may be at Hilltop or anywhere else, visiting her children, you are prohibited from being within 1,000 yards of wherever those places are at any time.
Right.
In this circumstance, with the prior assaultive criminal history, when I consider the violence of this attack, the $25,000 cash-only bond is an appropriately set bond, and the court will not modify it. Mr. Henderson, how would you like to set this case next?
Your Honor, I would just ask to set out about a month to 6 weeks so that I have some time to review the discovery in this case with Mr. Alloway. I might suggest July 2nd, if that's open to the court.
I think we certainly have some time on July 2nd to set this, so we'll add this to our docket for July 2nd at 8:45.
Judge is mad at you. Judge was not happy with you. All right, this is vulgar and triggering. This is both vulgar and triggering. In short.
And people VRA compliant to address the protection order.
Yes, Judge.
And go ahead with the request.
Like I said, this is very vulgar and triggering.
Ms. Beck.
Judge, we are asking that the
As the court is aware, I did file a protection order modification on behalf of the named victim in this case. She asked me to do that, so I did do that on her behalf with my client's consent. They do have a lot of property together, which they need to take care of and dispose of. So they are asking for a modification of the protection order to allow, whether it be electronic contact in public to take care of all that stuff. They would like full contact, but if the court doesn't feel comfortable with that, at least electronic contact and contact in public to deal with that. I would also ask that the DPS and pretrial be removed. Mr. Hawkins has been on that since the beginning of this case, which is April 4th. I don't see any reports that he's been in violation. I'm just asking that he be removed from the GPS and pretrial.
People's position on the protection order and then conditions of bond.
Judge, the people are objecting to any modification of the protective order. I would note that on the prior matter that was dismissed, it was, that protective order was full contact. And it is the people's position that he was not in compliance with pretrial having picked up this new matter, where the victim and the defendant got into an argument. The defendant said, "Why don't you call your stepdad and let him fuck you like you did when you were 7? The victim had been molested by her stepdad when she was young and had shared this with the defendant in confidence. The defendant was intoxicated, went upstairs to his room and laid down. The victim said she went upstairs and flicked the defendant's cheek and told him that that was not okay to say to her. The defendant jumped out of bed and grabbed the victim, threw her down onto the bed. The defendant placed his hands around the victim's neck and began to choke her. While choking her, the defendant said, 'You fucking bitch, don't ever touch me again, and I'm going to fucking kill you.' The victim said she could not breathe properly. The victim pushed the defendant away and slapped his face. The defendant pushed her down again, pressed her down with one fist and raised the other fist and said, 'I'm going to break your fucking jaw and I don't care if I go to jail for the rest of my life.' The victim got away and got in her car and drove to King Soopers. She said she was choking and almost threw up because the defendant choked her so hard. The defendant came out and began banging on her car. Officers observed bruising on the victim's chest, chin, and arms, and the victim also had photos. She did decline a forensic exam, and this case is being looked into being filed, Judge. The named victim is here. I did speak with her, and she would like to address the court.
If you don't mind just stepping to the side for 1 second. And Ms. Robinson, if you wanted to address the court. Good afternoon,
Your Honor.
What would you like me to know regarding the protection order?
I would like it to be full contact. We do have, it was in place before, and I understand that that was probably, it was hard to hear. I am not in fear. We do have properties, finances, kiddos, health insurance, life that we do need to figure out. I did move to my condo and updated my address, and in a separate situation, obviously not together. I truly feel like we need to be able to work through these things and talk through it, and I don't feel threatened or, unsafe.
Let's see. Anything else that you'd like me to know today?
I feel like some of that was just read was heated and out of anger. And obviously, I think we were both intoxicated at the moment. And so I just feel, I personally have been sober, and we have to get things figured out. So
thank you for being here today.
Of course. Thank you.
Just give me one moment to pull up the pretrial report. All right, the court has had an opportunity to hear the statements of the parties, the request from Ms. Robinson, as well as review the affidavit and the pretrial services report. The court does share in the people's concerns for victim safety, but I do recognize Ms. Robinson's request and the financial issues and the family issues that she's juggling with this. And the court is going to make one modification. We can start stepping down the protection order, see how things go, and then address further modification at the next court date in here. Or if it's filed in district court, then it can be addressed up there with any protection order. So we'll do an exception allowing for electronic communication and face-to-face contact in public places. So that includes FaceTime, text messages, phone calls, anything along that nature for the electronic communication or face-to-face with you and your family in any sort of public location, okay? But not returning home or anything private at this time, okay? We'll have you sign a new copy of that protection order and get you one to take with you. And then Ms. Robinson will also make you a copy to take with you. Anything else to address today? Oh, the bond conditions. And I'm sorry, Ms. Blinsky, any record on bond?
That was the same argument that I had for the protective order, Judge.
Judge, and he's more than willing to keep doing pretrial services, just the GPS.
Yeah, just so I can ride my dirt bike and swim with my daughter and do things like that.
So the court will modify the conditions of bond. I will remove the GPS monitoring. Given the court's modification and the cooling off period, the court finds that it's appropriate at this time to remove the GPS conditions. I'll still have him on supervised release program and monitored sobriety to address the community safety concerns and victim safety concerns. All right. Anything else?
No, Your Honor. Thank you.
Just a date.
Oh,
Just a date? Is there a date when you're scheduled to be back here, Ms. Beck, and you'd like me to try and set you on the same day?
This seems to be my division lately.
It's gonna rain.
Let's see. Here.
So school's
I'm
out?
here on June 10th, but I think that might be a little too soon.
Do the parties anticipate any movement in the next 2 weeks? I'm happy to set it June 10th if you think that you might have a decision on whether there's an upfiling or whether there's an offer in this case. If not, then I'd be inclined to.
I personally can't say Ms. Salibi is looking into the upfile.
Okay.
How about June 29th? It's a Monday.
June 29th?
I've not been on the new roller coaster yet.
And what time?
8:30.
June 29th at 8:30.
June 29th at 8:30. All right, I got one more clip and then it's over, guys. One more. 6 minutes long.
Okay,
It's a
so we're
short one
going to
today.
immediate sentencing, folks.
Yes, that's a request.
Good, please. Have you had contact with the victim, Mr. Davis?
Indeed.
Because I don't see anybody in the courtroom, so I don't believe you're going to have any presentation.
No, the named victim resides in Texas. I spoke with him about the proposition of potentially going to immediate sentencing, and he's fine with that and does not wish to address the court. So we've complied with the Victims' Rights Act.
Okay, thank you. All right, Mr. Williams. I've been handed a guilty or a plea agreement is what it's titled, and I do see that you signed this document. Does that mean you're able to read and understand it?
Yes, Your Honor.
Okay. The document indicates to me that you are going to be pleading guilty to count 2, which is menacing, as a class 1 misdemeanor. The sentencing stipulations, or that the judgment will be deferred and you'll be placed on unsupervised probation for 1 year, that you'll enroll and complete an online course in the realm of anger management, make a $500 donation to the La Plata County Humane Society, and abide by all laws, including dog leash laws. It looks like those are essentially the only conditions, other than you pay your court cost fees and any restitution. Is that your understanding of the agreement?
Yes, Your Honor.
The document contains the elements, and they're on page 2, continuing on to page 3 of the charge in which you're pleading guilty to. Do you feel you've had a fair opportunity to review those with Ms. Ault?
Yes, Your Honor.
Also contained in this document on page 3 are the possible penalties. Do you feel you've had a fair opportunity to review those with Ms. Ault? Yes, Your Honor. Do you have any questions about either the elements or the possible penalties for me? The second page contains the rights that you have in this matter, and they include your right to have a trial, to either a court or to a jury, to have the people prove the case beyond a reasonable doubt and appeal any conviction.
Oh, for the love of God, don't look it up. So in Pennsylvania, where I live, there's a lot of Pennsylvania Dutch. And a long time ago, I don't know when, but this park is ancient. It was there ever since I was a little girl. I don't know if there's a hayride or ponies or furniture making. That might be something different. This is an amusement park. It has really tiny little rides and a tiny roller coaster. It might have 2 tiny roller coasters now, and a dolphin show. I mean, it's an amusement park, but it has windmills, and it looks like the Netherlands. Dutch Wonderland. It's all Dutch themed. And it's along a line, it's along a piece of road that has a lot of Amish shops down the road, and to the right there's a full Amish farm you can check out and see. It's just a tiny little, everything's falling apart, but it's very expensive still, and I think it has very delicious hot chocolate, I think, if I remember, because during October and they have Halloween themes, and then during December they have Christmas themes with hot chocolate. I don't know if you're going to be able to get hot chocolate, Zach, but yeah, Dutch Wonderland is it's just a tiny little piece of joy we have here in Lancaster.
To a higher court, you understand, sir, that by pleading guilty today, you're giving up those rights.
Yes.
And when you understand also that when you plead guilty under a deferred judgment and sentence, once you complete the requirements, your guilty plea is withdrawn and the case is dismissed.
Sure.
Okay. Before I ask you how you plead then, Mr. Williams, do you have any other questions for me at all?
No, Your Honor.
Then 2 menacing is a class 1 misdemeanor. How do you plead, sir?
Guilty, Your Honor.
I'll accept your guilty plea as made voluntarily, knowingly, intelligently, and you're represented by competent counsel. Ms. Aldi, stipulating a factual basis.
Yes.
Okay. I will accept the agreement. We will proceed to immediate sentencing. Mr. Davis, do you have anything you'd like to say?
Yes, Your Honor. Just, I don't know if so initially this was charged as a F5 menacing. After a thorough review of the underlying facts and circumstances.
I think that's the only reason why I wouldn't want to be a nurse. Everybody points out rashes to them. What is this rash? Can you tell me what this rash is?
Circumstances and speaking with witnesses, essentially the factual backdrop, what happened was the defendant's alleged to have been walking on the river trail with his dog. There's no facts that suggest that his dog was out of control or aggressive. A couple passerbys were walking. One of the gentlemen there admonished the defendant that his dog needs to be on a leash. This person is the named victim, who, it's my understanding, and looking at some video clips that were taken by some passerbys, has a couple of those walking poles with him. Made mention of something about, the unleashed dog, that he would, use his poles to strike the dog. Although not a legal defense, I can certainly see how a reasonable person, if someone was making threats towards their dog, would cause some emotional tension with.
Deadass, if someone made threats towards my dog, I would be in jail that day. Yep. Call the police right now, sir. You went too far.
Person. There was a heated exchange. The defendant's alleged to have had a pocket knife on his person or in his pocket, made reference to it, and then a bunch of different accounts were given. But when I think those are the actual facts that happened. So given the factual backdrop in conjunction with the defendant having essentially no criminal history, being a otherwise productive member of society, he's already made the donation this afternoon to the Humane Society. The biggest important fact that the victim and the witnesses wanted was that expressing the importance of leash laws. So that's the rationale for making it a misdemeanor as well as unsupervised probation. I don't think that any terms or conditions would be warranted or needed. This defendant has been a model defendant thus far, has made it to all court appearances, has asked for permission to go to golf tournaments out of the state. And yeah, I believe this is an appropriate disposition to this matter. And if the court has any other questions, I'm happy to answer them, but I would ask the court to accept the plea agreement and sentence him accordingly.
Thank you, Mr. Davis. Ms. Hall.
You know, there's some dispute about the facts, but I don't think that's important to get into at this point. I think this is an appropriate disposition given the state of the case and the lack of criminal history.
Okay. Mr. Williams, you do have the right to say something, although you do not have to. Would you like to?
No, Your Honor.
Okay. I will accept the agreement as agreed upon by the parties, and I will issue the sentence as agreed upon and as outlined in the plea agreement. Restitution has not been filed in the case, so I presume you're asking me to leave it open, Mr. Davis?
There's not going to be any restitution sought.
Okay, so if no restitution is being sought, none will be ordered. All remaining charges will be dismissed. And what you'll need to do today is just take the sentencing order, Mr. Williams, over to the clerk's window to pay any court costs, fines, and fees, okay? If you have any trouble paying those, you can set up a payment plan with the collections investigator, all right? And then just provide proof to the court that you've completed the anger management course and the receipt that you've made the donation, and you'll be all done with this. Okay?
Thank
All
you,
right.
Your Honor.
Thank you, Mr. Williams. Good luck, sir. Thank you, Ms. Hall.
Sorry, I had to delete a troll. Even though the stream is over. Alright, guys. Thank you very much for coming. Now, like Kelly said, I want to remind you, I am going to stream Thursday morning. And then Thursday, I'll be off Thursday through Monday. So Tuesday I'll be back. So I'll stream Thursday morning, and then I will not be back until Tuesday morning. I'm going to take a couple days away from the entire world in my new house with my new car with air conditioning. Woo. Thank you so much for coming out. I appreciate it. I'll see you again in 22 hours. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.